As we move forward, he is in the footsteps of those who are coming. These are other mercies we ask in the most humble name. Amen.
Amen. Thank you. Apologies for absence.
Senator Brown will be late. He's on his way.
Well, he's in the precincts, so he has no comes in. Looking refreshed. Welcome, Member Brown. It's a Father's Day makeover. We move on since there are no more apologies for absence.
Member Daly has asked to apologize. He may be late.
Okay, very well. Very well. We proceed. Again, I want to welcome you all to this another sitting of the Joint Select Committee on Occupational Safety and Health. We are set today to continue with our clause-by-clause analysis of the bill. We are at part 10. I know the matter of the minutes would have come up on the last occasion, and we did indicate that
you will get mentioned by the end of the month, which is next meeting.
I have been advised that by the next sitting, that we should have a number of minutes before us for consideration, at which time we could take a position whether we defer them further or we make time at that, then to approve those minutes.
The JCTU has sent their apology.
I have been advised that also that the JCTU, the Confederation, has sent their apologies. They will be absent today, but they have indicated that for the next sitting, they will be present. Yes.
I spoke to the president this morning, sir, and they were still trying to get someone to attend today. Mondays are a little challenging for some, but they will have somebody attend, not every sitting, but as most as possible. That was the indication.
Yes, duly noted. Well, before us today, we have two sets of documents from the ministry for consideration. I think it's part 10 and 11 of the bill. Give me another one. I also, before us is also a copy of the Public Health Act.
It was requested.
On the last occasion, I know one member had requested that a copy of that act be brought before the committee. So, members, do you all have copies of the ministry's position in terms of part 10 and 11 along with the Public Health Act? I have to wait. Yes. So may we now proceed? Ministry, I will turn over to you.
Good morning, committee members and supporting team. This morning we'll be proceeding at part 10, enforcement notices. We have a document, Ministry of Labor and Social Security, review of part 10 of the Occupational Safety and Health Bill June 18, 2020. That's the document that we will be proceeding from. We have also received some comments from the Attorney General Chambers, so we will try to incorporate some of the...
Morning,
Yes,
Chairman,
Sergeant,
members.
yes.
We apologize, but we sent the comments this morning. So what we can do is we can try to assist the ministry.
Okay.
Because I don't
very well.
think you'd have had an opportunity to really go through them. So what we can do is Mr. Basco will just interject at the appropriate time.
Are you able to send a copy to the, yes.
Oh,
so-
the thing is, the protocol has always been we send it to the ministry.
yes.
But yes, we can email it to Ms. Frank.
Yes, and we will make copies so that the members can get. Yes. So we'll proceed notwithstanding. Yes.
I'll also want to apologize for the absence of Mrs. Campbell.
Yes.
She's out ill.
Very well.
So for clause 169, we're at improvement notice. Subclause 1 is to be amended to specify that the section applies where the authority reasonably believes that a person conducting a business or undertaking or person with management control of the workplace is contravening a provision of the act or regulations, or B, has contravened a provision of the act or regulations in circumstances that make it likely that the contravention will continue or be repeated, or C, is about to contravene a provision of the act or regulations. For subclause C above, this seeks to encompass previous amendments suggested in relation to clauses addressing the provisional improvement notice, the PIN, at the previous sittings of the Joint Select Committee. Also in subclause 2, OSH officer is to be deleted and replaced with authority.
Members? Substantially, the ministry is asking that the word person on subclause 1 be substituted to a person conducting a business or undertaking. And I think by this committee members, we all understand why that substitution is necessary.
As well as to include our person with management control of the workplace. And this is in keeping with comments before that the person conducting business or undertaking may not be there, but you may have somebody who is in management control of that workplace.
CPC, Mrs. Celia Brown?
Using both terms, unless, as I said before, we're going to define the owner, because a person conducting a business or undertaking is widely defined in the bill. And if you're going to add the person who is in management or control, you're going to have to explain, yes, yeah, you'll have, unless, yeah, I'm not seeing the relevance of adding it, but if that is the ministry's policy, we're going to have to see a clear definition of this person who has management and control, because in my view, the way person conducting a business or undertaking is defined in the Act covers both, yes, I think so.
And I know that the document that the ministry has provided specifies just the person conducting a business or undertaking. Mr. Mohan?
Clause 170. The reference to OSH officer is...
Before you go to clause 170, you would have heard from Mrs. Celia Brown in terms of the belief is that the definition of the person conducting business or undertaking is sufficiently wide to cover person with management or control of person with exercising management or control of the entity. I do not know if you have a comment. Are we still, is the ministry's position that you still use it going with both person conducting business or undertaking, or are we taking on the recommendation as put forward by the CPC?
We will take on the recommendations as put forward by the drafters.
Yes. Very well. Conducting business or undertaking, yes.
Sorry, Chairman.
Yes, Mr. Blasco.
Morning. With respect to the comment by CPC, it's just to make the point that throughout the bill, in earlier clauses, it does also apply to PCBU and person with control or management. The terms are used. So is it that the committee is considering a general revision of any clause that uses PCBU or person with management or control of the workplace?
Okay. Yes, let me hear from
We're
you.
going to have to decide which one we're going to go with, because I mean, when we come to the definitions, we'll see. Oh, yeah.
Chair, go ahead.
Yes, Member Gill. Yes.
There were some areas that would have considered the provision of information that you might not be able to reach the person conducting the business or undertaking, being the owner. But you would have to relate to someone in the arms of management who can provide certain critical information that may be requested. And I believe that there were areas of the bill that interchangeably utilized both. Now, if we're going to use one definition, would it mean that what is contained in section 5 would have to be expanded just to cover that?
Yes, Soldier.
I'm going back to page 17 of the bill, which is where a person conducting business or undertaking is defined. My first issue is that we use the defined term to explain the defined term. That doesn't make any sense. If you go into 5.1a, for the purposes of this act, a person conducts a business or undertaking, whether the person conducts the business or undertaking alone or with others. I don't even find it to be a very clear definition. And I think if you go through it, an argument could be made that it is only referring to the owners and not necessarily the person who has control, because a person who has control, may be a manager who has no shares, no interest at all. So I think maybe that was part of the issue why we had those two terms. But I do agree with Mrs. Seeley Brown that we really need to tighten up the definitions and really figure out what we want and then put it in there and then try and reflect it in the bill.
The same chair. When you look at subclause 4, it definitely excludes somebody who is a worker of that business or an undertaking, because it says a person does not conduct a business or undertaking to the extent that the person is engaged solely as a worker in or as an officer of that business or undertaking. So we have to, if we're going to include that other term, we're going to have to refine this definition when we come back to it.
Mr. Simmons, you wish to say something?
Yes, Mr. Chair. I just want to point out as well that there are other terms that have been defined in the bill, such as officer, which may be more useful than creating another term. But I would agree with both the CPC and the AGC that we need to tidy up all the terms, basically using less terms and creating another term in the bill.
Very well.
Because even if you look at the definition of officer on page 12, I think it's wide enough to include somebody who is operating or somebody who is manager or supervisor of that business. So maybe we can use the word officer, refine it, and stick to the person undertaking a business or undertaking. And when we need to refer to the actual person who may be running the everyday activities of that business, we could use the term officer as is defined here.
Very well. Member Brown?
Chair, yeah.
Yes.
I recall the earlier discussions where I believe I asked the question, how would this apply in the public sector? Would the PS, for example, be the officer? I think we got some understanding, and it is now for the drafters, having regard for all we have said, to fashion the definition that we need to capture all we want. And so if 5 is deficient, let's see if we can fit in the appropriate addition there to make it all embracing.
Yes, Mr. Basco.
The final comment is that we were recommending that clause 169.2c be deleted because we think that it's captured in A and B of clause 169.2.
On that point, Mr. Chair.
Mr. Simmons, yes.
I'd just like to add that I've done a basic scheme of the provisions in the bill so far, and from our perspective, we're not confident that an improvement notice is strictly speaking relevant to a contravention of the Act itself. So I think I recommend that they review the provisions in the Act and see if there's any provision at all that would be applicable to an improvement notice. And I do also think that it probably would be more relevant to relating it, not simply Act or regulations, but maybe the codes of practice to be introduced in the bill. Thank you.
Well, I want to hear from the ministry, but I don't know if members, you have any further comment before. All right, Mr. Mohan, you'd have heard Mr. Basco in relation to 1C that you are now seeking to introduce.
For
Mr. Basco, is it 169.2? 2C. Oh, very well. Yes, Mr. Mohan.
In relation to that, I think we'd want to spend a little more time to look closely at A, B, and see how to ensure that we're not missing anything. The remedy thing, operation causes a convention or likely contravention is before the contravention, and we would want to 2C, remedy things.
I'm wondering, Chair, if you really don't, you need 2C, but you really don't need A and B. That's what it looks to me. Because he's covered a lot more.
Yeah.
Cover both A and B.
Well, but let me hear from the ministry first, if there's any distinction between the three,
Chair,
and then we'll invite the drafters to come in.
If I could just add, if you look at clause 170, sub 2, it also says that your improvement notice could include directions about measures taken to remedy the contravention or prevent the likely contravention, which could include addressing the things or operations causing the contravention or likely contravention. 170 sub 2.
Yes.
Safe to say.
Chairman, just before the ministry comes in, it is true that to me you would either use for 169.2 is either C or A and B, and sometimes it's good to have the things separated and split out, but they come back down to the same thing.
Yes, that's what I.
And then it's reinforced again in 172.
Yes.
Mr. Chair, one other point here.
Yes, Mr. Simmons.
Just to note that in 169.2c, they refer to things or operations causing contravention or like contravention, but in 172, is either matters or activities.
Mm-hmm.
But that also leads me to wonder whether or not if these things or operations or matters or activities could be OSH issues under the Act. So they need to, which we dealt with some months ago.
Mm-hmm.
So I think there needs to be some relationship between the improvement notice and OSH issues as well, to see if there's any relationship at all.
Very well. Mr. Mahon,
Yes, so
take
what,
us to 169.2 first. Yes.
so for 169.2, it seeks to, A, B, and C seeks to look at different circumstances. Some are activity-based, some could be the conditions. And it doesn't necessarily mean that the contravention has happened. So the first one speaks to when there's a definite contravention. B speaks to prevent it from likely from occurring. And C is now speaking more to the activity that's causing the contravention or likely contravention.
So do you not think that the activity is already caught up in A and B? Yes, Mr. Alger.
Mrs. Seeley Brown is noting that this is how it's set out in New South Wales. but
Word for word.
But I don't understand it.
Very well. Ministry,
Mr. Mahan, may can just explain to us again the rationale being depicted in all three, so that we can understand the approach that may have been taken.
Yes.
Really an approach in all fairness to the ministry, because it's taken directly word for word from the precedent that was used to draft the bill. So unless we could probably, I don't know if we could find like a case or something that explains it, but it'll be hard for them to explain since it's coming, it's taken from the precedent just the way it is.
Yes.
Mr. Chief,
Yes, Mr. Scaffold.
I respect the opinion that is hard for them to explain, but I would want to believe that even though it's taken from that particular legislation, we adopting it. Most of our rationale why we adopt, because I don't want to believe it's a cut and paste, seriously. So even if it makes sense for us, what's the rationale behind it? Because as I read it to remedy convention and I remedy things at operation, I don't know if there's a difference there. Because if you have a contravention, there must be something causing it. And that's why you want to have a remedy in the first place.
Chairman,
Yes,
the fact that we are deliberating this particular clause, can you imagine if there may have been a breach and a party has sought to challenge that breach and we are not able to explain what the provisions of the law that we have established really meant. And so a dispute may arise. And it's a question now for the authority who were making this provision to treat with the matter without being able to understand why we gave them this provision. And so it's important for us to even, ventilate the provision itself. I can understand if we take a piece of legislation from somewhere else and we're trying to place it in our jurisdiction. But remember, we're always going to be dealing with contending views. And so it's important for us to seek some understanding. One of the approach I would want us to take, is that different market may very well drive different needs. And different cultures and understanding what is applicable to a particular jurisdiction might not necessarily be applicable to us based on various reasons. And so this is one of them that I am seeing when I look at it, how one can replace the other, depending on how you approach it.
Yes, Mrs. Celia Brown.
Even paragraph B is a little worrisome. I mean, I don't know if this is the way they draft in that particular jurisdiction has contravened.
Yeah, and you're referring to 169
Yes.
2B.
No, what? Yeah, because it says has contravened a provision in circumstances that make it likely that the
No, we're at 169 2.
1B, 169 1B, in
Okay.
circumstances that make it likely that the contravention would continue or be repeated. Now, when we draft and we just speak to a contravention,
Yes.
and if you have contravened, then certain things would apply. They're probably, this is probably the way this jurisdiction would draft provisions like these. But I think even B would be difficult to implement because I don't understand how that would work.
Chair,
Yes, Member Brown.
I read 169 as giving authority to the ASH officer, and 170 as saying something different, but from giving the authority. It's not in contradiction. It simply says, you have the authority now to make these improvement notice. These are the things that you should put in the improvement notice. And so I see them working together. I don't see a contradiction there. I don't see a problem. And so I support that. Give thought to likely contravention, and I can see in several ways that taking place. You start to block off an exit. That's a likely contravention. You seek to remove some guard from a machine. That's a likely contravention. So I see no reason to have difficulty with the two sections going together here.
Yes, Mr. Baker. Yes, I'll take Mr. Baker before you, Sergeant.
Yeah, in support of what is being said, one of the things that makes it easier, and as Senator Gale alluded to the possible conflicts, one of the things we usually do is, even our regulations, it is set out broadly, the terms, the contraventions in the Act, and then in the regulations we stipulate in more detail some of the general things that can be classified, so that when all parties are clear, when a notice is to be served, you know clearly where you have breached, are the standards that you need to maintain in order to prevent the contravention of the Act. So if you try to serve the notice in opinion, especially when you deal with systems, it's more difficult. If you're dealing with human beings, if you're about to do something, it's kind of different because it's easier to deal with. So I think probably if there's anywhere in the Act that clearly defines in a generic way what are the main contraventions, then we probably could be on our way.
Yes, Sergeant.
Yeah, I'm back at 169, 1B in the bill, or the proposed same 169, 1B in the amendments, and I don't agree with it. Has contravened a provision in circumstances that make it likely that it will continue or be repeated. That's not how we craft things in our jurisdiction. It isn't. So normally we have three positions in law. It is being done, it was done, it is about to be done. They have it here in their A, B, and C on page 1, except in B, they go on to talk about in circumstances that make it likely. It would be very hard, I want to almost say impossible, to prove the circumstances that would make it likely that the contravention will continue or be repeated. Why would you want to put in that extra limb in it? You would want to talk about the current situation, what already occurred, or what is about to come. Because I think that limb in B is actually trying to capture the C, which is about to come. But it would make B very hard for anybody to prove. So I don't think you need the limb, that extra limb in B, about in circumstances that make it likely. Because you're looking at something prospective, which you're going to cover in C. But again, you're supposed to have some proximity to the event. So you can look and, same thing Senator Brown was sort of saying, it's captured in their C on page 1.
And I know that C has just been proposed by the ministry. Right. The bill itself has only A and B under 169.
So we can just say, Chair, the person is contravening, has contravened, or is about to contravene a provision of this Act. That's it.
Yes.
That formulation, you can repeat that formulation, it's so precise.
A person is contravening, has contravened, or is about to contravene a provision of this Act. And it covers everything.
Ministry, you have heard the drafters?
Yes, we have listened and we will be guided by the comments of the drafter.
All right, so we have settled on 169. One, take us to 2 now, Ministry, because the issue, as I understand it, is that persons are saying that with A and B, there's no need for C. That is 169 2C. Or if you're going to go with C, then there's absolutely no need for A and B.
Yes. Well, in C, what we're trying to do was to ensure that any other things directly related to this contravention. Because remember the contravention, yes, there is a breach, but there may be other things that are operating to outside on the periphery of this contravention. So the things, as set out in C, the things are operations, right? These are the activities.
So C is dealing with the cause of the contravention.
Right, and the activities that causes are likely to cause.
Yes.
So,
yes.
Right.
No, but
let me hear carefully.
If you damage floor,
yes,
cause a broken leg, then you remedy the floor and fix it and deal with the floor, so you'd have to get rid of the cause for future occurrences. So I don't think you need to separate them. One is a cause and effect relationship.
Well, that is actually after the fact, but you can have a floor that it has a break in it, and you're going to fix the break, but this floor is supposed to have grip, and you fix it, so there's no break in the floor. The floor is smooth now, but that now can cause another contravention because you can't slide.
No,
because it's slippery.
You as the USH officer going there and supervising should have pointed out to the employer or the manager that though you fix the floor, you prevent the break in the floor, but you have no cause it to be too slippery. So that's another potential damage. So your job as the USH officer is to prevent, it's not to wait.
And that's what C is speaking to. You know, you want persons to be aware that you're fixing a contravention, but you should not be fixing it to say yes. In isolation of the other environmental factors, you fix it. You don't wait until it is fixed and then you're saying that, oh, you have breached this other requirement in that the floor is now slippery. Well, so you need to ensure that in fixing this contravention, the other...
No, but the author would have the standard, right?
Because we would not... Remember, the improvement notice gives you a time frame within which to fix it, It doesn't necessarily mean that the USH officer will be there to supervise and oversee the fixing of that.
No, but you give me so you say, while you're dealing with the improvement, then the work is going on?
So you issue the improvement notice because you have a contravention, and you give them a time frame within which they should fix it.
But my understanding now, so in that particular area where the floor is damaged, workers should not have access to that area while you are fixing the problem. And so if you give me 2 weeks, then at the end of the 2 weeks, I expect the USH officer to come back and supervise that you have met my standard and you give me the
Probably,
go ahead.
probably
I'm
what
just talking about administratively.
what I'm saying is that after it is fixed, it wouldn't be supervision. It would be just to verify that it is
Yes,
fixed.
no, that's what I meant, you know.
So pretty much we are saying during that period, whether you cordon off the area so that the workers don't have access to it, that is something that should obtain. But then in the fixing of it, you can't say that you have fixed this, but then in fixing it, you have now caused another contravention. You should be looking at the circumstances, the environment in which you have to fix and what are the requirements to make it safe. So you don't just fix the contravention.
Not clear.
I'm sorry, I don't take the point at all, because when you have breached something, when you're being told to fix it, it's not that you're fixing it to your standards. You're fixing it to the standards that are there, laid down by the authority. If you don't comply with those standards, you would not have remedied the contravention. You would still be in breach. You would still be in breach. You have to fix it in a way that would, but this is how every other regulator does it. When they send a notice, you go back and inspect. You have to ensure that you have not created any new damage as well or any new danger, but that is a part of it. And you are supposed to, so it's a part of the notice that you will issue, to say you must not just remedy it to what was there before. You must remedy it in a way that is consistent with the law. And the law would have had all the standards in there. So I don't think that is what is being covered under this C.
Yes. Let me hear.
It can be left to the place of business or the workplace to just remedy the issue and move on. You must get a quote unquote, go ahead. That all is now well.
Mr. Simmons, let me hear.
You want to expose yourself that you have to issue another improvement notice.
And that is what we don't want to. So
yes, let me hear Mr. Simmons, because we have to move on now, Ministry. Yes.
This is just a possible example. I'm not saying I necessarily agree with the explanation given by the Ministry of Labour, but another example could be, for example, if you had, for example, a wet floor, and you notice that there was a leaking pipe, and you fix the pipe, so you have now remedied that contravention. But in going through, they noticed that there was another pipe that's rusting that may start leaking in a month's time. Maybe those are other things that are likely to cause a contravention. Just more like a devil's advocate type of example, if that works.
Mm-hmm. So wouldn't that be captured in B, Mr. Simmons, what you have just indicated? Because I think what is before us is that A and B, and we will not use C. C is a repetition of A and B combined. Yes. 170 now, Mr. Mahan.
170, the reference to OSH officer is to be changed to authority. Subclauses 1A, B, and C are to be amended to capture the situation where the contravention is about to occur.
The point has been made by Mr. Simmons in respect of 172 and the use of the word matters or activities causing the contravention. For consistency, I think he has highlighted the use of those terms. Is there any comment? Mr. Simmons, do you wish to make the point again?
I'm just highlighting that we weren't consistent with the language throughout the section. If you notice that, well, we have now deleted C, which spoke to things or operations causing contravention or likely contravention. But if you look down to the third line in 172, it speaks of matters or activities causing the contravention or likely contravention.
In fact, Chair, we had also suggested that those words should be deleted if our suggestion to delete 169.2c was accepted.
Okay. So what exact words, Mr. Basco, that you are proposing be deleted?
We propose that the words or the matters or activities causing the contravention or likely contravention be deleted from clause 170 sub 2.
Yes. Members? The clause as proposed by AGC will read, an improvement notice may include directions concerning the measures to be taken to remedy the contravention or prevent the likely contravention to which the notice relates. Yes, Member
The
Brown.
notice would have captured the activities or things causing or likely to cause. That's what has been said.
Yes.
So therefore, it's not necessary here.
So, that's it so. Ministry?
We agree with the deletion of those words.
Okay. So members, we agree to this? Yes. Proceed now, Minister.
171.
Sorry, Chair.
173, they're asking for the editorial to change
Oh,
date to date. 170 sub 3
yes.
on page 112. You agree with that?
Yes, we are in agreement with that as well. Change the word day to date for subclause 3 of 170.
Okay. So we agree to that. 170, yes, subsection 3. Substituting day to date. Yes, Minister, proceed.
Mr. Chair, one point, again, for
Yes.
consistency in language. At 170 subsection D, we speak to the date by which the person is required to remedy. And at 173 is the date stated for compliance.
That's what we just...
Not date and date, or day and date. It's rather, it says date by which a person is required to remedy. And on the other side is date stated for compliance.
So are you saying they are the same thing, Mr. Simmons?
I'm just speaking about the consistency in language.
Okay. Yes. Okay. So we proceed.
So that's a matter we'll leave for the drafter
Yeah.
to adjust. So for clause 171, the error in the placement of subclause 2 should be corrected. The number 2 should be returned to the margin. So if you look at subclause 1 ending, there's a 2. What we're saying is that that should be moved down to another line.
Yes. We agree to that, members, yes. Proceed. 172.
172,
Sorry, 171. 171, 2. A failure to comply with the notice shall be liable to conviction to the shall you likely to face a penalty. It matters not the nature of the contravention. Is there room for warning rather than jumping so quickly to fines?
Ministry, I'll allow you to respond.
well, our position is really to aid, assist, and encourage compliance in the first instance, but we're not seeing that, and based on the nature of that contravention, then it may mean that this is something that has to go to court sanctions or penalties. You know, going out and doing inspections to determine contravention is where we have to look on the history of these operations. What are their history in terms of compliance? So there are some other factors that will be looked at, because sometimes you may observe a contravention, and to the extent of it is not that serious, but then it can be fixed quite quickly. So if you visit and you recognize that there is a contravention, a guard is missing, and the organization of the compliance history of always ensuring that the guards are in place, it may be that the maintenance person somehow left it off, and then you would now say that this guard is missing, they need to put it on. But representatively, most of the guards throughout the premises has been in place. So it is really depending on the nature, as you had rightly said, that a warning can be given and it is put in, the situation is remedied.
I'll allow Ms. Michael to speak before you come in. So Ms. Michael, yes.
Thank you, Minister. If you look at 170 subsection 2, you will note that the improvement notice include giving directions. So the OSH officers would have already been given directions as to how to improve. In that, certainly it could be implied to the persons that there is some notice to you that if you do not fix, then we will be taking the other steps to avoid serious injury to workers.
Back to you, Member Brown.
Chairman,
Sorry, recommendations that they will be given.
I don't want any injury at all to any worker, but I have to strike for balance as a legislator here. As I read these sections, the enormous power of the OSH officer is clear. And I compare it and say, well,
the authority.
Well, the OSH officer and the authority, but and the OSH officer. And because the OSH officer is going to report to the Director General. And I'd say, does the police have all of this power and discretion? Because this gives them a whole heap in terms of their ability to affect business. And so, it also leaves it open. Skeffrey, we're going to take him to court. Dr. Ferguson, we're not going to take him to court. The enormity of the discretionary power to the authority or OSH officer can be a dangerous thing. And this is why I'm saying, if it is uniformly first contravention, a warning in writing or something like that, failure, then we move. Then we know it's clear that equal treatment will apply. But I can't take it here. And as impressed chairman, I visited the Gramercy plant in Louisiana, alumina plant, some time ago. And what struck me was the absence of the caustic smell that you smell when you go to Yuatan or you go down to Alzal. And I was inquiring why. And the people in charge said to me, well, they operate a system here. The first time you come, we charge you $10 for argument's sake. Second violation, we charge you $20. Third violation, we charge you $30. So that it gives a progression to how we treat things. And it works. So I just want then, because I just don't want to be sending people to the courts. The other thing I want to say before I close on this, Chairman, having read these sections, I don't know if the intention is to recruit all the people from the AGC, all the lawyers from the Parliamentary Council, all the lawyers from legal reform, to take them down to the authority. Because everything here is going to court, going to court, going to court, going to court. And unless you have a whole pile of lawyers, probably more lawyers than OSH officers, it's not going to work. And so I'm not so much into carrying people. We're going to review the law, but I'm not into carrying people to court ever so often for sometimes technical, sometimes issues that we may dispute. As an employer, may dispute that this is likely to cause. All right? And they have nowhere to turn but to go down to, if it's in Kingston, Halfway Tree, courts, you know, we need to have a...
Member Ferguson, before I get to you, I'll just say, all right. Okay, very well. Very well. Your turn, Member Ferguson.
Dio, Dico. Dio. Okay, Gary, optimal. Chairman, I agree with Member Brown. My only concern as we go along, this bill that we have been pursuing for so long, years, and we have gotten to this point. While I believe it is important to have a balance, and we must, in any good bill, have fairness on either side, balance. My concern is that if we water down some of these things to the point that you really don't, you cannot, simply get away for the same reasons that he has pointed out. Mr. So-and-so, you will use that discretion to what the other person is going to be going before the court, as we have seen with many other laws out there. So I think we have to be careful, because the workers of this country have had a very difficult time. A number of workers, and when I say number, I would want to believe hundreds, thousands, have died because we have failed to protect them in places of work. This bill is designed, even with the balance, to protect our workers. And we have seen many instances the kind of exposure that become lead to cancer, all different kind of sickness. And to that extent, I believe that we must take that on board, because I see the wisdom of not just giving power to be used in a particular kind of way. But we have to be cautious that when you get this bill through, and it's a good bill, having taken all the time that we have taken so far, but you don't want to be coming back too soon, as I've seen with a number of JACRA and other bills we hurriedly pass, and then you end up having to come back. So I'm just saying, you want balance, but this bill, in spite of all the talk, it is to protect significantly the workers of Jamaica that have gotten a raw deal.
Yes, Member Gill.
Chair, we encourage and support compliance. The employers are not here to defend themselves, but sometimes the trade unions can help to defend employers.
Huh?
Yeah, man. That's where the balance comes in. And I can appreciate Member Brown wanting to promote a progressive approach towards remedying or to being compliant. And I give you one example. The OSH officer, in terms of the notice, has that prerogative to establish the time frame for that notice. Correct? Yeah. And so in that regard, I have seen a situation where a business had to remedy a situation, but remedying that situation required at the time the importation of certain raw materials. And so the time frame that was established was not conveniently enough to allow for that importation in the time that was specified and agreed on. And so, agreed. And so, it had to be extended. Now, in this case, if there was a failure to comply within that specified notice of enforcement, then, as Member Brown indicated, you would have gone to courthouse. And so, where in the scope of that relies the flexibility that may be required. And so there are going to be, Chair, those circumstances that would dictate some level of flexibility on the part of those conducting business. Because we don't want to create laws that are straitjacket in nature or shackles of any form. And so that's why in the first instance, under certain circumstances, we ought not to go to that stage of the courts.
Mr. Chair, that's to,
Yes.
before we go to the solution, just to reinforce and support the point. While the first instance is not to go to the court, we have to have a clear trajectory to reach there eventually, if you may. Because the discretionary powers that we want to leave in the hush office or the authority is what I'm not comfortable with. Because justice must not only be done but appear to be so. And we understand the reality of our country and our society, where the corruption is something that's still rocking this country. And so an officer may come to a business that has the same issue and propose one way forward, and then goes to B with a similar issue and propose another way forward. And then that's where you're going to have the challenges when there is no standard practice going forward. So I don't want to give this some power in this bill to an hush officer to determine the directions going forward, because we might not have that equity across the board. And the bill must not have those deficiencies where an individual has that awesome power.
Yes, Soldier. Yes, Mr. Simmons.
But I'm just repeating a point that I made earlier, and it may be of some assistance, just asking the minister to consider it, that some of these contraventions may be similar to or the same as OSH issues, which we considered some months ago. The ministry has not yet come back to us on how they intend to review that section, but that could be an avenue which they can use to deal with these issues without going to court as a first instance.
Very well. Soldier?
Right, so I know the reason why we're having some difficulty with these provisions. These provisions are very general. They're very general because they are dealing with a multiplicity of different issues that can arise in this bill. Now, if you look at other legislation, and I'm going to take, for example, because I was just looking at it, the NRCA Act, they are very specific about the different notices and the different issues that can arise with contravention for very specific things. So there, the discretion is not as wide. It wouldn't be as general because they have made it very specific to all, different issues that can arise. However, the approach in this bill is just to have this very general approach to deal with almost everything that precedes. Any contravention, you can have this improvement notice. Now, if you drill too deep into the details, it may not apply to one or other of the different contraventions that can occur in this bill. So I recognize that. I also recognize that if you look at 170 sub 3, to me it's an unusual provision because normally we don't talk about the date of the notice must be reasonable. But again, I think it had to be built in because of the wide scope of this improvement notice and the wide scope of the bill. But I understand the concerns that have been raised, and I wonder if perhaps another approach could be considered. And if that approach is considered, it may assist in narrowing some of this wide discretion, where you have a it's not really phased, a tiered approach. So you start with, in the Casino Gaming Act, they didn't just go to offenses. And they didn't go immediately to suspension or revocation of a license. They had what they call disciplinary actions, which is letters, issuing, because they wanted to really encourage compliance and not necessarily carry people to court or even revoke a license. So they had these things of letters of warning, letters of admonishment, censure letter, reprimand letter, and those carried their own weight. And after that, you could then do revocation or suspension of a license. Now, there were some things that weren't considered appropriate for even those letters. Some breaches are so egregious, you go straight to suspension. And I kept thinking to myself, well, and it was going to come up later, in terms of us linking it to the suspension of the registration of these establishments, because we haven't really made that very close link yet. But you can have that sort of graduated approach. It's something to consider. And you can then put in more specific timelines. So rather than leave it to any authority to say, for this one, I'm going to do this, because it's a high-priced private lawyer, you know what? Let's back off a little and put a different kind of approach compared to the public. So, you can have different approaches just because of who you're dealing with. The law could then be a lot more prescriptive and a lot tighter when you have this tiered approach, when you say, because you're doing a letter, then you have to act within a certain time, and the authority doesn't have that much discretion. Now remember though, the authority still has to be given a little bit of discretion, because no matter what, we cannot always envision all the circumstances that may be applicable in any situation. But I'm just suggesting that as well.
All right, Mr. Baker, you next, but members, I'll direct you to clause 194 while we listen to Mr. Baker. I don't know if that is going to help. 194. Yes.
Thank you, sir. While we appreciate the need for a tiered approach, just to warn that based on the nature of this act to protect the workers' health, the risk must be taken into consideration. And so, while there is a tiered approach, depending on the need for speedy remediation, there must be a protocol in place to provide for the skipping of aspects of this tiered approach. Because there may be breaches that will be immediately dangerous to the health and even the life of the workers. And in such case, you may have to move directly to closure of the premises, prosecution, or whatever it is. But you have to have that flexibility.
Chair,
Yes,
just
member.
to
Yes.
first housekeeping. I realized, was it last time, that there are two bakers?
Yes.
So we probably need, for purpose of answer, to differentiate them.
Okay.
Even though they answered right, I may be looking down and seeing the names.
Really?
One is Richard and one is Everton, I think. So we just need that's
Okay,
it.
very
In terms
well.
of what the soldier had said,
Yes.
I can't but think, she didn't really say it this way, but forgive me, Mrs. A, that casinos historically have been a zone where people are brought to court, and a certain type prefer to hang out. A certain type that are not like our employers. If David One was here, he would say, certainly our employers doesn't fall in the criminal categories that may hang out at casinos. Not every casino player is a criminal, you know. But the criminals like to use it. That's true, but he might have. He might have. So just speaking to you. So if the approach to a difficult industry like the casino, where international regulations exist, and it takes a tiered approach, I see no reason why we shouldn't do that to our employers in the country. Truth be told, Chairman, Am I just defending employers? No. If you go and take, it does, and I'll tell you why. If you take the employer in Morant Bay to court too often, he may shut the business and work. Yeah. But don't mix it up with the one that your friend Nestor keep talking about. Yeah. So in other words, so my point is that you can impact the workers. You can impact the workers too on their livelihood while protecting them, and we must protect them. But it need not be to climb up. It's still, the courthouse still work out there. All them steps up to the, well, Paul Bogle had to climb once. So we have to just find that balance. I could pick Sablamarto, I could pick anywhere. Point is, I just choose one bit because it's closest and it's my parish and my father's birth. So I just say that because, again, we're quick. Part of our problem in this country, we are quick to call everybody criminals. In other words, they're going to break the law, so let's make the law so tough. We do it to politicians too, all right? And we need to therefore not take that mentality in developing this bill, where we feel that everybody's an offender. Let's use it to get them to comply and work with it. That's the approach I want to take, and I would recommend to the ministry to take in this. This is a major piece of legislation necessary, but I keep saying we only need to give people one bad reason to oppose the entire edifice, and it is going to come down like Columbus statue.
Ministry, your time.
Yeah. Well, listening to the deliberations, I think we have a tiered approach, because issuing a notice is not an immediate requirement to go to court. Because if you look at 170, clause 170, D, the date by which the person is required to remedy contravention or likely contravention of this act. So what we have done here is to give them some time, right? We have also, under 172, says an improvement notice may include directions concerning measures to be taken to remedy contravention. So we are making recommendations there. And some of the recommendations may be just to ensure that we accept that there's a contravention here or there's a dangerous situation there. The OSH officer can give a direction that the workers are not supposed to be going there. And even after all of that, if the time that we have given at 170, clause 172 here says that the authority under subclause 2, well, we are going to have an amendment.
Clarification, Chairman.
Maybe
yes, clarification. What is the time that you give Senator Skeffrey? What's the time you give Member Ferguson? What determines the time?
There will be different entities, different operation, different circumstances, and as my colleague at the back, Mr. Baker, Richard said, that you have to do some evaluation of the risk. You also have to look, as Member Gale had
Chairman,
said.
there's nothing in the law, just address that. There's nothing in the law which says this. It is just, you decide whether it's 7 days a year, or 5 days, or 14 days, depending on the circumstances. That
the point is made, Member Brown.
Yeah,
the point is made. Yes.
Mr. Chair, I just want to come in here.
Yes.
Let us not draft this current bill with the practice probably under the Factories Act or so on. It's a new bill, a revolution. We have to be specific. We're transforming the behavior in the workplace. And as Senator Brown said, I don't know if we just, for a regulation, will speak to the guidelines. But it can be that we will, or we may, you may, for what category of contravention. and you give timeline for what? It has to be specific, so I don't know if it can be spelled out here, but the regulation which will give life to the act will have to. But let us not continue to give the impression that it's going to be up to the discretion of the USH officer. Because that's what we want to move away from. That's where Senator Brown started the debate and the technical team came in. Because if we leave it up to the discretionary power of the officers with the greatest intention of men / women, we will not get the desired outcome.
Yes.
And the law has to be clear, because we don't want one law for uptown and one for downtown, or one for urban or one for rural. So Scarefree in deep rural South Manchester have an operation, you stop me and you prevent me. But then we're afraid of the big man up at the top. Let's be frank, let's understand. It's when you draw in these bills. No, we have to be clear now. Whichever side divide we are on. We have to be clear how Jamaica operate. And when you don't give the officer this discretionary power, he or she would not do anything wrong, you know. You can't say, but the law give me this power. And what we are saying here collectively, in my interpretation, let's try to be as specific as possible with the limitation of discretionary power, but it can't be this wide and this general. That's all we are saying.
Yes, Mrs. Seeley Brown.
May I suggest, Chair, that we examine the provisions that Mrs. Aldred raised in the Casino Gaming Act with the different tiers before you get to court action and criminal conviction, and where you can go straight to court action and criminal conviction. Look at them, and then next week you can just come back and just tidy up.
Yes. But
please use it as a model.
I think what Mr. Mahan was doing, because the position put forward is that there is a tier system already built in what is here. So he was explaining it. He was explaining it, and I think it goes as far as Section 194. That is why I've asked you to look at Section 194, because the issue of the notice, directions, 194 even allow the PCBU to issue an undertaking to say that I will comply within a certain time. Yes.
Chair, but
Yes.
it's still, even with 172, I think it can go further, as how it is done in the Gaming Act, what Mrs. Aldred referred to. So I still think we should look at it and come back and see how we can reshape this in that manner.
I take that, Chair. I take that. And I just want to say, when I look at the word 94 and the undertaking, the ash undertaking, that's a whole new thing that has to be dealt with too. But I'll wait when we get to that, because it says an ash undertaking is not an acceptance of guilt, not an admission of guilt. And then you take it from there and take them to court again. I tell you, you are going to change office, you know. You're going down to wherever the authority is.
Chairman, thank you. While we're deliberating the tier system, etc., I'm just trying to figure out if it's here or elsewhere that provision would be made for health risks that may not be immediately apparent and may not be as overtly obvious at that point in time, and when could be redress for a worker who may be thusly affected. I don't know if this is where it would be in terms of the consideration for this tier approach to reporting, etc., etc. But certainly those are circumstances that we have to consider.
Very well. Ministry, yes?
So,
yes.
I was trying to outline the hierarchy, and you added to it, Minister, Chair. Just to point out to Member Longmore how this was written, we did not specify. It was general, as our Sergeant has said. We didn't specify any particular type, the type of risk, whether it is something that is physical, biological, mental health related. So we were just trying to capture that here. And when it comes on to the complexities of what we have to deal with those particular areas, chemical, physical, biological, and so forth, we were of the view that in regulations and code of practices, that is what we would be referring to, because the code of practice provide the practical guidelines as how to do the remedial, what is necessary to mitigate, eliminate that risk. So from that standpoint, we were looking at it. The ASH undertaking was a measure to, in part 10, which we'll be dealing with, part 11, which we'll be dealing with further, is another means of which we don't have to necessarily be going to the court. So even with the improvement notice, we even try to put a hierarchy inside there that allows it to even extend the time for the notice. And this would be with consultation with the entity, as Member Gill had spoken about in terms of trying to remedy the contravention. You may have to look at other circumstances, and then it gives the authority. You know, we're not saying the ASH officer, but the authority to determine that, you know, an extension is there and necessary to reduce the risk.
All right. So having heard the proposal that's put forward by CPC and AGC, the ministry will come back to the committee in respect of 171. So we will proceed to 172 then, Mr. Mahon. Yes.
172, the term ASH officer should be replaced with the term authority. AGC.
I see, yes, the AGC has
read some.
Yes.
We need to delete subsection 1 or put it at the beginning of clause 169, because we have been dealing with issuance of improvement notices from the beginning. So I don't know why that 172.1 speaks with it's a bit out of place, that clause. Or take it out and don't put it anywhere, because the provision clearly deals, the part clearly deals with issuing of enforcement notices.
Yes.
Chair, just because of 172.3, is there a duration for the notice? Are those going to be regulated? Are we going to see these in regulated?
No, but go back to 173 that talked about it must be reasonable. So that's the only guidance you really have, which, as I pointed out before, it's slightly unusual, but I understand why it's done because of how general this notice provision is and how wide the remit of the act is, that they perhaps thought that this was the best way to address it, but it's very vague and leaves everything
open. Is it the best way? Is it?
Use the mic, Mrs. Seeley Brown, yes?
I get an answer from the sergeant.
We have moved on, Member Brown. Mrs. Seeley Brown, yeah.
From a drafting perspective, where if you're going to do regulations for the different types of business or undertakings, then you can say here as maybe prescribed, and then you prescribe them, like if you have occupational health and safety, factories, regulations, whatever, you have it for different, whatever PBCUs that the undertakings or businesses, you put the notice period within those regulations. But I'm not sure how that's going to play out, and I don't know how
That's
the ministry is here.
Whether or not they're going to be specific time for notice. Because one thing I learned, and probably learned badly, is that notice must be specific. And if notice must be specific, then here it is no any notice I want to give. I want to give you 5 days, I want to give you 7 days, I want to give you 14 days. And so there's no specificity to the notice period. And I hope that some guidance can be taken on that.
Chair.
Yes, Member Gill. Mr. Baker, before you come in, I'm going to hear from Member Gill. Yes.
I mean,
Everton.
we talk about the notice has to be specific. And there has to be some equity in terms of how you treat with the application of the notice. It can be one notice for you as opposed to one notice for me. But the notice has to fit this particular situation that is being applied. And so that's why it's important from the onset for us to be able to identify the specifics in terms of the notice, that it's detailed somewhere, whether in a regulation or whether it comes in a set of schedules. We have to make that determination. And you notice how long we are treating with this piece of legislation here. So if we have to wait on a regulation to treat with it, I don't know if we want to consider applying the set of notices in some sort of a schedule so that it's known from up front.
Yes, Mr. Everton Baker.
Right,
Yes.
sir. That's the exact thing what Senator was saying in respect to precedent set already in the Public Health Act and its attendant regulations. We have the nuisance regulation that set out the time, the breaches, plus the time in which you can serve, up to 30 days. But the notice itself is valid for a period. So you can act on that same notice. But you can't, you have a time based on the nature of the thing to give a specific time. It can't exceed a certain number of days based on the regulations, but you can act.
Use your mic, yes. Yes.
The only concern is the length of time it may take to do the regulations, and then you may not be able to issue
The
any
suggestion that
enforcement
came from
notices.
Member Gill is to consider the schedule.
Or you can put it in the schedule.
Yes. Yes, Sergeant.
Schedule to this bill. So if you're putting it in a schedule to the bill, the schedule would have to be ready.
Yes.
You see the
No,
difference.
the instructions have to be given.
The difference with the approach of the schedule here is that if you have to wait on the regulation is going to be so comprehensive. You can't present a regulation with only the notice. So we have to wait on that. So why not establish the schedule now so that the schedule can form part of this?
All right, Ministry. You have heard the comments. It's now for you to respond.
Based on the comments that we have heard, we just have to look back at this and revert to the committee.
Very well. Proceed.
But I just want to know,
Yes.
in terms of the proposal, do you accept the broad proposal for the notice period and so on in a schedule rather than regulation? Because that is important. If you accept it, as was said, some instructions that has to be given now to start that process.
Well, as I said, as a team, we have to meet and sit and look at and revert to the committee.
Yes.
So we have heard, we have noted.
Mr. Simmons, I am allowing you to speak, sir.
Yes, I was just looking at section 170. I'm just wondering what would move the USH officer to extend the compliance period for the notice. What would cause the USH officer to extend the compliance?
172.3.
I think a step is missing.
AGC.
I was going to say that we had comments, but I think those all have to be deferred until we figure out the notice period. Because how do you extend something and we don't know the period?
Yes.
You can't even extend when you don't know a period.
Yes.
So this 172 really, I think we would just defer our comments. I was going to just say we wouldn't bother going to our comments on 172 now until 170 and 171 are properly addressed in terms of the notice period and all of that.
The thing
Yes,
I may say where that is concerned is the application of a principle. Whether or not circumstances may dictate or warrant an extension based on the investigation or the inspection by the USH officer. Remember, I raised the issue where the importation of raw materials and that person conducting the business may say, listen, I need help right here. It's important, it's critical, but this is my situation. And at that point in time,
It's just the principle that may be involved.
Yes, Mr. Mohan.
Yes, and to follow on what Member Gill was saying, you and even AG had mentioned it about having a level of flexibility, because there could be a situation where as we have seen, a supply chain has been disrupted, and the PCBU can show evidence that he has made attempt to remedy the situation. So in those circumstances, you may want to extend the notice. And the thing about it is as well, when I mentioned about the directions, once the authority has issued directions that would cause the risk of injury, illness, or death to be averted within that period through which they have given the time for the notice to be applied, then we would just be really focusing on fixing the contravention. So we need to have that flexibility to give them the additional time if circumstances may show that it is reasonable to give them an extension.
Mr. Chairman, I just have a question.
Yes, Member Skeffrey.
For knowledge. CM 172.4, you say extend the in the section compliance period means the period stated in the improvement notice. Who determined that period? I mean we have pointed out the weaknesses. Yes. But the original, I just want to understand the original intent as you having it here. Let's say, no, I just want to be clear what you see, because the challenge I have, these things they're in the bill of drafting, reviewing, but there must have been some intent to things. I just wanted to know, assuming that we never have a problem. Give thanks we do. But what would how would you operationalize this section then? So the notice period, who would give it? And is there a standard approach? No? I just want to be clear.
172.4 is just really speaking to the fact that the time frame that is put in that notice, the date, that period that is given is the period through which you expect them to.
So whatever date you put there, you could extend
it.
But
right.
There's no standard.
No, and you have to appreciate, it depends on the circumstance, because you have to know, look at what is the contravention, what is the outcome if that contravention remains, and you will do your risk assessment to determine, given the resources that would be required to remedy the contravention, to set a time to say that it should be corrected by this time.
And Member Skeffrey, I think that's what the committee is saying, that the guidelines for the exercise of that discretion must be.
Yeah, but I just want to understand. You see,
yes.
Mr. Chair, the committee was saying that, but I just want to be clear that the ministry understand the context. So I want to know the original thinking. So when a new proposal comes, I can understand how to assess it in that context. Because as I see, this was just highly discretionary, very, very, very general, and therefore this might require a lot of work to put these timelines. So we don't want it to appear as if they're going to come next week and give us something. This is almost a policy shift. Let's understand that. And that's why I was hoping that the ministry would say that to us as a committee. That's why I'm trying to put that in there. But this is almost, as I'm listening, there is no guideline, there is no standard approach. As I listen, that's my conclusion. So this almost requires some policy directions too.
Maybe, Chair,
yes,
they could categorize it in risk term, likely to cause death, likely to cause serious injury, likely to, and then based on those, everybody would know what the period of correction or compliance would be. That may be an approach. I don't want to take it more than that, to say, as a thought, as they go to do it, to look to see if you can define it under risk and make the period risk related.
Yes, Soldier.
The reason I was suggesting that this really, the committee members can't really properly address 172 now and the ministry can't respond now is because it's so closely tied to the actual issuing of the initial notice. So ministry wouldn't be able to give you all the parameters, the rationale for why you have an extension, why you wouldn't have an extension, the extension period, because it's going to link back to the particular PCBU. All of this is going to be go back to the type of breach you can have specific to the type of business establishment. I really do think, so it's not that I'm being dismissive, I just think it's a package. They won't be able to explain all the rationales right now because they'll have to go through it. So, I mean, I am wary as whether it could really be in a schedule, and I really think perhaps the kind of detail that you may need, it perhaps is better it's done, but it could be done as discrete regulations. I don't know, you can ask the CPC if that is a possibility. So rather than have, because you can have that, you can have one huge comprehensive set of regulations, or you can have discrete regulations dealing with very specific subject matter, and perhaps this could be, right, so in terms of your notices, the prohibition, not just improvement, it could be dealing with notices and all the procedures and everything that go along with them could be dealt with in one set of regulations rather than in a comprehensive set. But I'm outside of my area now. This is really for the OPC to say whether that could be done, because I suspect for it to be done in a schedule, all that work has to be done right now to go in the bill. It would have to go in the bill right now, and I suspect, because when we go on now to prohibition notices, this is where this deals with serious risk to health and safety. You're going to go into, we're wading into another sea of issues right here with the prohibition notices as well. I'm just asking for that kind of consideration to be given.
Chair, just to clarify, this bill would be nothing without the immediate passage of discrete regulations or a schedule, because then you can't go into anybody's place and tell them anything if we don't have that accompanying the bill. So I am reading that there's an urgency. Whichever approach we take, there's an urgency that must bring those things.
Yes, Member Gill. Yes.
Chair,
yes.
when I made the recommendation, it was against a background that you don't want to leave the authority exposed to the risk of being challenged. That was the first instance. And I certainly cannot understand and appreciate the context to which the ministry may find itself in, because if you never walk with something or plan to walk with it and we send you back for it, it's a challenge. But in the first instance, when you go back to consult, it has to be on the premise that you would have been convinced by this committee of the necessity of having it somewhere. If you're not convinced, then you're not going to come back with anything. So we want you to understand and appreciate, based on the concerns raised, that you were first convinced so that you can go back to those that you report to convince them. That's the first approach. The second thing is that, however you can present it to us, and Mr. Aldred has indicated one possible option, is just an acceptance that, yes, there are ways to treat with it. It mightn't happen now, but when? And that you're coming back with it. But it's a very integral part of this legislation. And this legislation just can't walk without it. And that's what we're trying to convey.
Ministry, you have heard the submissions. Yes.
And the deliberations, as I said before, are duly noted, and we will take into consideration all that has been raised by the members and the supporting legal team in our discussions.
Very well. So we move to 173. Yes.
Clause 173, so we're looking at a different type of notice, prohibition notice. Subclauses 1 and 2 are to be amended as follows. If the authority reasonably believes that A, a workplace or part of a workplace, a plant, substance or structure at a workplace is in such a condition that death, serious injury or illness, or a dangerous occurrence may emanate from an immediate or imminent exposure to a hazard. B, an activity is occurring or may occur at a workplace that is resulting in, may result in, or will result in death, serious injury or illness, or a dangerous occurrence emanating from an immediate or imminent exposure to a. In the circumstances set out in A above, the authority is required to give a direction to the person conducting the business or undertaking, which prohibits the opening of the workplace or the carrying out of a work at the workplace or a part thereof, or the use of a plant, substance, or structure until the authority is satisfied that the matters that give or will give rise to the risk have been remedied. In the circumstance set out in B above, in this document, the authority is required to give a person who has control over the activity a direction prohibiting the carrying out of an activity or the carrying on of the activity in a specified way until the authority is satisfied that the matters that give or will give rise to the risk have been remedied.
Yes.
In paragraph A, we will have to sub-paragraph certain things because it's not reading well. When you speak to a plant or a substance, it can be in such a condition that it is likely to give rise to injury or something else. So, yes, so we'll have to just...
So you will redraft?
Yeah.
Okay,
if that is what the intention is,
yes,
we will have to just, yes.
Very well.
Mr. Chair.
Yes, go for it.
I know, just for normal language, it's a serious injury. But in a workplace, what you think might cause serious injury can be highly subjective. So how do you quantify this measure determine? Yes. Let me see if it links to. Just remind me, please.
Yes. Ministry, are you able to assist the section?
And I remember when we were discussing that, we had a lot of deliberation around that definition. I don't think we came to a final definition, because we had concern as a committee. But I remember even an example, the teacher sits on the chair and fell, and then you might think it's no problem. And then you have issues. So a chemical exposed at the workplace, I might say just a simple spill, but it might cause respiratory damage, person asthmatic, different person have different underlying condition, given the reality now.
And
so
also,
I think we need to tie in the definition, we need to tie down the definition of serious injury before we can even have greater deliberation and acceptance of this provision.
And to add what I previously mentioned in terms of the time frame, because sometimes the injury is not immediately as dangerous or as threatening, but subsequently that manifests later on.
Yes, Mr. Basco, you, yes?
Well, it's two things. The first, Chair, is that Member Scaffer was indeed correct. Just looking at the summary sheet, clause 36, some decisions were taken about removing this whole concept of immediacy, and that the team was to look at the CARICOM model to look at how serious injury or illnesses have been treated. So I think ultimately the committee may wish to defer in respect of that substantive matter until the serious injury or illness has been treated with. And then the other thing, generally consistent with what we've been saying, is there seems to be this approach of serving notices on persons. But given the aim of the bill, which is really sort of to regulate and to protect the interests of workers, we were recommending that the actual service of the prohibition notice should take place with the person with control of the business or undertaking. Because we note, separate and apart from that, that an OSH officer can issue a direction to the actual person who is carrying on the activity, but we think that the actual notice should be served on the PCBU.
Could you just repeat that again for us, Mr. Basco? Are you saying that when it comes on to directions, then those directions could be issued to the person with management or control, but the actual service of the notice, prohibition notice, you're saying it ought to be served on the person conducting the business or undertaking?
For this particular clause, what I'm saying is it empowers a direction to be given to the actual person who is carrying out the activity to stop. But the actual notice which they have to serve should be served on the PCBU.
Okay.
I understand Mr. Basco to be saying there's a notice and there's a direction, two different things.
Yes.
And he is right, absolutely right on that. The concern I have is, and I noticed the AGC addresses it at clause 175, where you said the marginal note should be amended to also refer to the compliance with a direction. There's no definition for direction here. There's nothing. Direction just appears under 173.2 and 172.3, and I think it needs a definition somewhere or some authority somewhere to say you can issue a direction. And certainly at 173.3, direction may be given orally. Everything else has been in writing. So it comes to E says versus E says, or is it she versus she, or she versus E? In another legislation with which I'm familiar, when it comes to oral evidence, it has to be given in the presence of a credible witness. So I can't, even though it's going to follow up with a written notice, if you put oral there, it just opens the door. But I didn't get it. I didn't understand it.
I think, Member Brown, what is being contemplated here is that if the OSH officer turns up to do a routine inspection and he observes a contravention so serious that serious injury or death is likely, then in those circumstances he's now being empowered to issue the prohibition notice. But you recognize that the law is saying that the written notice should be issued as soon as practicable thereafter.
No, what it is saying that you must confirm the oral notice.
Yes.
And I'm saying the oral notice ought to be in the presence of a credible witness. Otherwise, you're going to prosecute me and you say, I gave you an oral notice and you, sorry? The direction, you don't believe in it. I understand that, and I'm with you.
Yes.
Huh?
All right. Yes, Mrs. Silva.
Chair,
Yes.
from my notes in relation to clause 36, which I think should relate to this section, I think we should use the same language. If we're going to redefine, as what Mr. Bashir was saying, serious injury or illness, and that is the term that we're going to use, I think we should use the same terms in clause 173, so it will mean everything that's here and anything that may be prescribed, because you see how wide this definition is in clause 36. So I think remember we had agreed to put it also at the beginning of the bill, so it will be right in the general interpretation section, and then we use that same language rather than speaking now of a serious risk to the health or safety of a person, which implies that it may be something else apart from a serious injury or illness. So just to be consistent with the language, once we've tidied this definition, and just use it throughout.
Very well.
Clarify something.
Yes.
All right. And just, this is for clarification now. and I am guided. But if you're the last paragraph that you're applying on page 2, carrying out or the carrying on of the activity in a specified way. So specified way applies a directive. But when you use words until, wouldn't you want to insert a specified time? Because we're going to be giving notice. It's just a concern I have. Same. But it's just how you're giving direction here, and then you're using the word until, and until is only known by the OSH officer.
It's not drafting language.
Yes.
It's not the way we draft, and we won't say it like this. Because this creates a whole heap of subjectivity on the part of the OSH officer that really can't work.
Yes. And I'm happy, Mr. Seeley
I'm not
Brown.
far off, so I'm not far off with my concern then.
As presented.
Yes.
Just in the same way we fixed the clause before that we said we would fix, we would have to fix it. Yeah.
And remember, this is not drafting because, yes.
Just some clarification, Chair.
Yes.
Is there a difference between recommendations and direction?
Yes. Ministry?
Yeah, there is a difference between recommendation and direction, because the direction is what must be complied with. Because given the circumstance and there's a serious risk, then the OSH officer ought to give directions to, as much as possible, reduce any exposure to that risk. However, the OSH officer may make recommendations to the PCB to say that, okay, regarding this particular risk that we have, you may need to look at this code of practice, for example, or the standard, as a best approach as to how you will be remedying the contravention or the risk that is there.
Is that
Chairman, sorry. You see, I'm out in the streets. I'm a bicycle shop repairman. I have improvement notice. I have a prohibition notice. I have direction. I have recommendations. And I'm going to have to go now and go down to wherever the AG's office is and beg them a free service to clarify for me which is it that applied to me, the little bicycle repair man. Whether it is prohibition, is your officer coming to beg assistance because I can't pay the high price lawyers so, from the side. Right? So I need, and you're going to say I'm going to legal aid. So I need it to be clear to the employers and to the workers with so many notice. As I say, I repeat it. Prohibition, improvement, direction, recommendation. We need to be clear what it is, what each is. And then need to be defined. So it make it easier so we don't have to bother the people who have to deal with constitutional matters later on.
Chair, on a completely very light note, I would have asked Senator Brown if he has complied with the Bicycle Act. So over the weekend, Mr. Basco found a bicycle second-hand repair law. You have to be registered. So do you have the license? It's, what year was it? It's old. It's old. A bicycle second-hand repair law, and you have to have a license to be able to carry out the activity. There is, I think, a $1 fee.
Wow.
Oh, 1947. Yes, $1 for the fee.
Yes. Yes, Ministry. All right, before you come in, Mr. Mahon, yes.
Is it that you can be issued an improvement notice and a prohibition notice in relation to the same contravention? No?
No.
What? Yeah, because if I'm conducting an activity which involves a serious risk to health or safety, why then won't I? Why can't?
And there's something to be done.
Yes, and there's something to be done to remedy that risk. Why can't I be issued both?
Well, you know, earlier I was trying to explain the hierarchy in terms of how we issue these notices. So let me give you an example. It is a requirement for you to have first aid. You would issue an improvement notice because if you may have some of the items, but you don't have suitable or sufficient items. So you would issue an improvement notice. There is no risk to the safety and health of a person because you don't have that, because first aid is really something that is required after. But in terms of the prohibition notice, if there is a serious risk to the safety and health of the personnel, then that is when you would issue that notice. For example, if you have a situation where someone is working at height and they don't have the necessary safety protection in place, whether it's be engineering controls in terms of guardrails or they have their safety harnesses, etc., then you would now issue the prohibition notice in those instances because there is a serious risk and the imminency of it too as well, because if a worker is working on a platform.
But that person would have been in contravention of some provision of the Act as to not to have had whatever gear. So won't you still want them to remedy that?
But that is why it says that we will issue a prohibition notice for them to prohibit, if it's an activity, because they're working there, so they will be prohibited from working there until they have now satisfied the authority that what is required to be in place, whether it's by the code of practice or even the regulations, right? Those are in place and that would have satisfied the authority that the risks have been eliminated or reduced.
The hierarchy that Mr. Mahon is
I
speaking.
recognize this, Sergeant.
Oh, I'm sorry.
Yes. No, I recognize you. Sergeant, I recognize.
So Mr. Mahon is explaining it beautifully. The problem is it's not reflected in the bill. So the bill doesn't indicate that there is a hierarchy, and I still don't understand if you were actually, because if the ministry's policy is that you can't issue both at the same time, that should be clear in the bill. But I'm not sure that should be the approach. I'm not sure, because you could be doing something that is causing serious risk. It could be a leak in the roof that has exposed that you have asbestos. So you may be issuing a prohibition notice, but wouldn't you also want to tell them to fix that contravention and to issue the improvement notice, unless it is that the sanctions and the enforcement controls are different for both notices? And right now, I don't see that difference even in the bill.
And both notices would have to be different.
No, of course they would be different.
Right.
They would be different,
Yeah.
and they would focus on different things. So this is why I'm wondering, why is one in isolation of the other, except perhaps it's because they are so generally provided for that we don't have those kind of details. But if the ministry's intention is you can only issue one and not the other, that needs to be reflected in the bill, and it isn't. The whole issue with the hierarchy, that's not reflected in the bill either. There's no hierarchy with the notices.
Chairman.
Yes, Ambalomo.
A question here.
Yes.
Because I'm trying to put it all in context. Is there presently, and I was asking Senator Brown for his guidance here, is there presently a requirement on the ministry's or the registration agency's part, if somebody is going to establish a business, whatever it is, and upon registration, they are provided with the requirements for compliance? because I'm trying to approach it from a different angle. And the breach occurs where such is not adhered to. Because essentially the tier system, we're struggling with this whole thing of serious risk, serious. All of that is clinically based. All of that is actually the risk and the severity of the risk is based on health, is based on the damage that is potentially done, which is a technical issue that is medically directed. Now, if that is given, and that requirement is given before the establishment of whatever operation, and a breach ensues, irrespective of how severe that breach is, a breach is already in place based on the guidelines that were given, because they should have had it in place already. So I think we're trying to grapple with the tier system, the interventions that should be happening for punishment, quote unquote, when there could be a easier and a simpler solution where if it is given and depending on the breaches, etc., that determines the level of correction. So I don't know if we have that in place, and again, I bring back the point of the lack of the input of the medical side to the drafting, because if you have the guidelines given, the breaches are easier to recognize.
Yes.
My point is, Chair, if an activity is occurring at a workplace that involves some sort of risk, you are breaching some aspect of this law, even before that activity takes place. So I can't see you not, I can't see you not issuing an improvement notice along with your, there can be circumstances where you may have to issue both, or just.
Well, my understanding though is that the improvement notice does not necessarily halt your operation, but the prohibition notice halts the operation. And if you look at 74(2), yes, directions to remedy the breach. So the two schemes, as I understand it, is that improvement notice does not result in us halting the operation, but the prohibition notice brings the operation or a part thereof to a halt until it is remedied.
Mr. Chair, I just want to go there as my as I read on page 112, 173(2), and I see clarification from technical. My understanding, while you now have both at the same time, because I just said one is to prevent the work from continuing, and one is for improvement. But in both cases, for example, when you have the provision notice, you say you will not, until you remedy the situation causing the problem, you will not be allowed to continue. So I'm asking, is that the reason why you wouldn't need to have both? Because the provision notice also speaks to seeking remedies for the problem, and until you solve the problem, then you remain unable to operate, so to speak. So is that the context where you don't need both?
Mr. Mahon?
Yes, because what we want is to ensure that persons are given the opportunity to fix contravention when it is not a serious one. Because what qualifies the prohibition notice is that there must be, not in addition to the serious risk of injury and illness, the immediate or imminent exposure to that hazard. So what is there, just as how the improvement notice would have given directions as well and recommendations, the improvement notice, the prohibition notice will also give directions and recommendations. But additionally, that part of the workplace, or if it's the entire workplace, you would be issuing like what you call a stop order notice. So you will you're ceasing operation in there because the extent of the hazard is of such that there would be imminent or immediate exposure that can result in the serious injury or illness, loss of life, and so
That's a
forth.
basic question again. So what you're saying, just for understanding, under the improvement notice, the work can continue. Under the prohibition notice, the work must stop. Am I right in interpreting that?
Not totally. Under the improvement notice, right, work in terms of the entire workplace, right, can continue. But where you have the improvement notice, a direction can be given to prevent the worker from being exposed.
But so, I thought I was getting some clearer clothes, but it's getting darker. Yeah, so, but what's the difference then in the prohibition notice?
You don't want to give the impression.
Let me give you an example. Sir, I work in the lab, the chemistry lab at a bauxite plant. There's a leak in the gas line. You speak about seriousness, and that's where I'm not clear. Because again, how you determine serious? There's a leak. There's a leak. I work in an environment where I do the radioactive elements. And the case that should have that element got damaged. The person who don't understand chemistry and radioactivity might come in there and smell a stench and say, oh, it's normal work, but it can cause serious damage or illness to the person. Yeah, we have a station recently at Villa Road Primary. Where while they were cooking lunch for the children, they were delivering gas at the same time. And then we know all the two don't mix. Heat and gas at the same time delivering. And there was a leak. But you could pass there and see that leak prior to. And so it's a small leak, man. So it didn't really cause a serious issue. But we saw it resulted in death. So what I want to be clear is that what's the difference between both notices then? What's the end game? What's the consequences to the workplace when you issue one against the other? I'm not clear. I thought you were going there in my thought process, but I say the clothes gathered again.
Before you come in, Mr. Mahan, Richard Baker.
Oh, thank you, sir.
And then Everton Baker. And then you, Mr. Mahan. Okay.
Well, I'm submitting that both notices can be served as a single, on a single notice form. It's a general notice. Because in any instance, there would be a breach of the regulations, of the legislation. So the notice would have three aspects to it. The breach, for one. Two, you would have what needs to be done to remedy that breach. And three, you have a time period for it to be remedied. So if it is for an improvement, the breach is that there is a deficiency. You take steps, you fix the drain as a measure of improvement and the time. If it is something that is dangerous that can cause death, it is still a breach. You may need to shut down that aspect of an operation. So there's a machine that you have to close off. You can't use it, so you stop the use. So the remedy is to stop the use of that machine. In that case, you won't have to give a time because you can't use that machine until it is fixed. So the one notice can serve all the aspects that you can come across which resulted from a breach of the legislation.
Yes. Yes.
I don't want
Member
to
Brown, yes.
deflect from what has been said, but I just wondering, and this is for the drafters, is it possible to list, trying to get Mrs. Celia Brown attention,
Celia Brown,
because this is
yes,
for you. Is it possible to list all the notice in like a clause to say an OSH officer may issue any of the following? So we see all of them, because in a way, as you read, you buck up on prohibition, you buck up on improvement, you buck up on direction and recommendations, and then you buck up on non-disturbance. So if we put them so people see an hierarchy of the notices, and then we may define them so it's clear to people what each of them is about. Because as it is now, we just buck them up, and we have to comply with them without being made clear what each is about.
Yes, yeah. Okay, yes, proceed.
Yeah, that can be done at the beginning, and then you say what each notice would apply to. But then, Chair.
No, it's different.
It's different?
Turn off your mic.
Yes. We'll wait on them. Very well. All right, Ministry, you will know. Well, we will hear from the Ministry in terms of their explanation. I think one of the committee members are still trying to make a distinction between an improvement notice and a prohibition notice. Yes, so I think we need to be clear on that, and then we. All right, Ministry, proceed.
All right, so in terms of giving some clarity on the notices, the improvement is we know that there's a contravention. It is not one that is serious, so we're giving you some time. Work can happen within the workplace, but work related to that activity must be suspended. And the remedial work is done, and we give you a time frame to do that. With the prohibition notice now, because it is a situation where there's an imminent risk to the safety and health of the worker from exposure to the hazard, right? That one, it needs to be able to allow the PCB and the workers to know that, hey, we're not doing anything at this part of the workplace, or if it's the entire workplace that it affects, that work is going to be suspended until the necessary remedial actions are taken by the PCBU to make the workplace safe again. The non-disturbance notice that Senator Brown had made reference to, which is further down in the document, is really to allow the authority the ability to investigate where there is an accident, because the accident has already happened. It could be one where the person was injured, or it could be what sometimes person call a near miss. You have an explosion, but thank God nobody was injured, but investigation to establish the root cause of it. And if it is disturbed, it will affect the probity that is required in that investigation to determine the root cause, because we have an obligation as an authority to also make recommendations to prevent future occurrence of these accidents in the workplace. That is our aim.
You this notice, every time he wants to investigate an incident, because remember he has powers of the non-disturbance notices.
Oh, we are not yet at non-disturbance.
Sorry?
We're not yet at non-disturbance. I think
we're not there yet. I was just explaining the notices.
Oh.
So as we reach that point, we can speak some more on that.
We are still trying to distinguish between the improvement
so we want,
and the
so the name of the notice is also intentional. Once you hear improvement, you know that you have some time to fix what is there. Once you hear work is happening in the workplace. Once you hear prohibition, you know that it is like a cease and desist. Because the example I gave before in terms of the first aid and the absence of first aid equipment.
No, Mr. Mon, I think she's referring to prohibition notice.
Let me hear what
she's asking why do we not. Yes.
The prohibition.
Yes.
Well, it could be named that as well. But in terms of the principle of what it seeks to achieve.
Let me hear Mr. Member Gill, yes.
In his submission just now, in terms of the improvement notice, you made reference about the suspension of activity. And I ask myself the question, for argument's sake, suppose it needs adequate lighting. Are you going to suspend activity in that particular area as part of the notice? Because you may be able to carry out some activity that doesn't require the adequate lighting, but the adequate lighting is an improvement that is needed. So all you're suggesting is that, listen, you need to improve the lighting, but you don't have to suspend activity. But in your submission a while ago, there was an interface of suspension in both. And I just wanted to be clear in terms of the approach that is being suggested.
So Simmons, you wish to intervene?
Yes, Mr. Chair. I'd like to say first, I actually do understand the distinction that Mr. Mahon is making. However, I do think both improvement and prohibition notices can be rationalized. Just based on the word improvement, I don't think you need a prohibition notice. I think improvement can, depending on the type of improvement notice that you're issuing, it could either be one to allow you time to improve or one for you to stop activity right away, because either way, they're dealing with an activity which presents a serious risk to the health or safety of the worker. I actually do prefer the language, just to add, under section 173 that keeps it general, because that is the way the act is drafted. And I mentioned earlier, I do have a difficulty with how the improvement notice is issued, because I am still unable to identify a provision in the act based on how general it is that would warrant the issue of an improvement notice. So if they rationalize both sections, I think it would make it easier for the reading of the act and the committee on the whole. Yeah, that would issue a improvement notice.
Yes, your mic.
Asking him if he's not, when he said that he's not seen any reason to issue the notice, is it that you're not seeing any provision you speak, or is it that you want the provision to speak to the exact section that is contravening? That's what you're saying? Yeah. Yeah, because which provision?
That's why I made
Can
it
I
the
make a
session.
suggestion about how we could move forward? Because I
Yes.
think as much as we're getting the explanations, well, I for one am getting a little muddier rather than clearer.
Yeah.
So I'm just going to ask, is it possible that the ministry, just in ordinary language, just set out
Yes.
what's an improvement
intent?
notice? I
Yes.
know it may sound like a dummy's version for me. What is an improvement notice? Why would you need to do an improvement notice? When is it to apply? When would it not apply? What is a prohibition notice? When is it to apply? What is the basis, the rationale? Just setting this out. And then, because when we get to the non-disturbance notice, I have to tell you, I also get a little muddier when I try to think of how it applies in relation to the incident notification, which started on page 40. The problem is, I understand that the ministry has been thinking it through, but it's not reflected on the pages we have in front of us. And so to try and mesh what they're saying with what we're seeing is creating a little bit of a problem. And then the provisions, their proposal to amend still doesn't have that. We could understand it, and if it's just clearly set out, not in terms of drafting language, but just setting out the ideas, I think it would really help a lot of us, especially me.
Yes. Ministry, I've heard the suggestion as put forward by AGC. Let me hear you.
So given the concerns, we will put together something in ordinary language that I hope that,
To guide the drafters.
yes.
Yes.
Just to also backtrack to what was said before about the CARICOM model, we did do a comparative analysis and we submitted a document at a sitting in November, which we're looking at the definition of serious injury and illness. And at that sitting, we had also recognized that the language that was used in the CARICOM model was even more vague than what we had proposed in our proposals. So that was a document that was the 7th of November 2019. So I'd encourage us to look back at that document at some other time as well. But we are doing our investigations, looking at other jurisdictions, and it is somewhat a bit of a challenge in terms of coming up with a definition that will satisfy all persons. But what is evident from this piece of legislation is that it has to be accompanied by some interpretive guidelines. The definition section, as Solgen had recommended, that once we have completed this exercise of going through the bill, that we could now look back at the definitions, but we will also need to have some interpretive guidelines because of the natural ambiguity in using ordinary language.
Mrs. Celia Brown.
He says, what do you mean when you ask for interpretative guidelines? What's that?
Just as how you'd asked for us to give you a definition in ordinary language as to what constitutes an improvement notice, what is a prohibition notice, what is a non-disturbance notice. That is really what I'm speaking to in terms of our guidelines, that there is no ambiguity. Once you read the letter of the legislation, you have this as a reference, that there is no ambiguity or uncertainty in terms of what is being expressed.
Appreciate that if we drafted clearly based on whatever you would give to us. You don't need that because you really shouldn't need interpretative guidelines with legislation. Legislation should be drafted very clearly without ambiguity. So once you give us the instructions and you put it down in that detail that the SG has asked, and we are able to put it in proper drafting language, there would be no need for any interpretative guidelines, which I don't believe in those. I think once the law itself should be clearly drafted so that there's no room for ambiguity and interpretative guidelines.
If that was the situation, the definition pages would take up the whole
Yes.
And that is why,
and that's what you don't want to happen.
Well, Minister, I just suggest that in terms of the matters for which you need some guidance, that you have discussions with CPC.
Yes, we will provide those guidelines to Ms. Celia Brown.
So let us proceed to 176.
Chair, I think we have not done 174.
Well, I think it was flowing from the general conversation. 174 and 175.
All right, I'll proceed to 176.
Yes.
176. The authority is to be given the power to issue non-disturbance notices. Just want to highlight, it is not the policy intent of the ministry to limit the powers of the police and firefighters in relation to an investigation at the site, because this was something that was raised before, so we want the drafter to recognize that that is not the intent.
Yes, but
here.
Mr. Mahan, could you explain again what is a non-disturbance notice?
Okay. So the non-disturbance notice is to give the authority some time to do a thorough investigation to a site where it needs to look at the conditions and the environment after the accident or dangerous occurrence has occurred, so that the root cause can be established to make recommendations to prevent future occurrences of that accident or dangerous occurrence.
So is it that it is issued to facilitate an investigation?
Yes, it is not something that may be required in all instances, but it is there to facilitate the investigation, the thoroughness of the investigation.
Yes, Mr. C.D. Brown. I come to you, Mr. Skipper. Yes.
I'm thinking, Chair, if we go back to page 40, part 3 of the bill, which deals with incident notification, I'm thinking that maybe since this non-disturbance notice deals with this notifiable incident, maybe we should push it further around in the bill and speak to it in clause in this part. Because part 3 just deals with incident notification, right? And the right of the director to investigate these incidents after occurrence and all of that. And if this notice is tied only to this, to the notifiable incident, I think it should move further in the bill. We should put it in part 3 of the bill, because that is specific to notifiable incident.
So you're suggesting to repeat it in...
As AGC is mentioned in clause 165, Chair, which says an OSH officer may, where it is expedient to do so, hold or cause to be held a formal investigation in respect of an accident or disease contracted or suspected of having been contracted in the workplace and of its causes and circumstances. I'm thinking that we should move it because it deals specifically with notifiable incidents and when they have occurred, and part 3 contains that entire procedure as to how to deal with notifiable incidents.
Ministry?
Yes, we have no objection to that. We also wanted to raise with the committee as well, in situations where there is a suspected case, it has not been confirmed, and you would want to issue a non-disturbance notice so that some research can be conducted to determine if there is really a hazard in the space. That also be considered in the drafting of it.
But that would be based on a situation where some report would have been submitted to you.
Yes, and we want to ensure
or some issue raised.
Yes, and we want to ensure that we have that ability to, based on what is raised and the concerns, that we can say issue a non-disturbance so that our investigation can be done.
I can appreciate that, Chair, because let's say the employee representative may have raised an issue of an occurrence in the workplace and it warrants some sort of an investigation. What you'd want to do is to put that stop order notice so that you can properly investigate, rather than you having a person conducting business to go cover up. Right?
Well, yes, we
no,
want to be...
You don't have to agree with me, you know. But I'm just highlighting a possible situation.
Yes.
Go ahead. Yes, Member Skipper.
As I said, the ministry put it here, trying to be clear about the intent of not the police and the firefighters. But I just want to, as I understand it, the police would have first right to that scene and or the firefighters. So if when you want to investigate and they put a stop on you as the OSH officer, what do you want, what relationship you want to have while you reinforce the policy here? Because the police could say this scene, we have exclusive right, we're gathering information and so on, so we don't need you to even come and disturb it while you want it to remain undisturbed for your own investigation. So I want to be clear where's the line of demarcation and where's the collaboration to prevent conflicts and confrontation.
Mr. Simmons?
Quote unquote. I just want to be clear. Because the police can stop you for an unlimited period and you can force them to give you access until they so determine. Because they have first right as the protector of the nation.
Mr. Simmons?
Yes, Mr. Chair. When I was reviewing this section, I myself, just following upon Senator Skeffrey's point, at what stage or which type of incidents would involve the police and which one would involve the police and the firefighters. There are going to be incidents which won't involve either of those two. So I do think if there's any section which needs a kind of tiered approach, it will be this section. So, okay, there is a non-disturbance notice given, but in cases of death, then you make provision for the police. In cases of fire, then you make provisions for the firefighters. In all other cases, it will be just the OSH officer, something like that.
Mrs. Seeley Brown?
And that's why I'm saying, because if you look at clause 35 and the definition, because it speaks of occupational accident, occupational disease which results in death, so it tears it down. So that's why I'm saying if you put it around here and you create that power of the OSH officer to issue this this non-disturbance notice, then you can make the exceptions. It doesn't apply in a case of death where a police officer should have, you make that exception, but link it back to Part 3. Right now, Part 3 doesn't speak to these notices, and these notices do not speak to Part 3, but to say that they apply to notifiable incidents. So I think it would be clear if
Chair, I understand, I agree with all the positions. It's the order of precedence that we're talking about. Take an accident at let's one that I'm familiar with, a backside company, massive train derailment, requiring the fire brigade with a fatality. What is the order of precedence in that? Now, add to that, because it's backside, the Surgeon will tell us the Mining Act also applies. So you have all of these agencies who may agree to do a cooperation, multi-agency investigation, but what's the order of precedence and where would safe OSH fall in all of this? Because certainly because of the fatality, you're looking at manslaughter among other things. So you have a crime scene, you have a fire scene, which may also be a crime scene. It may not be a crime scene in other circumstances. Mining may be required because the Mining Act says you must investigate all those. With the OSH Act, does that element of the Mining Act still stand? So there's an order of precedent that they need to fit in, and I don't know if it impacts you. In the Indicom case, in the case of a fatality, police fatality, it's clear. Indicom has primacy over the scene. Here, I don't think they are claiming primacy at all. They're claiming the need to be effective. And so we need to look to see if a multi-agency approach may assist or hinder their work.
Mrs. Seeley Brown, you have a further comment?
Chair, on the point that Peter had raised, the whole issue with the police investigation, if we look at clause 39(2)(d), it speaks to, it says subsection 1, which provides for the preserving of the site, does not prevent any action, and this says that is associated with a police investigation. So all the more reason why we need to just move the whole notice, the non-disturbance notice around here too, so these provisions would apply. So it's there. It's in the legislation.
Ministry, you have heard the recommendations.
Well, we were moving based on the recommendation that flowed from a previous sitting where it was, even in relation to clause 39 and the mention on the police, that other laws already sets that precedents, and including expressing it in this manner in the bill would have been limiting. It would appear as if it would be limiting the powers that are already existing under the other laws that are there in terms of the JCF and so forth. So we just wanted to make that clear, that for this part, and for the drafter to understand that we don't want to put in any provision that would in any way seem to be limiting the powers that already exist in the other legislations that govern the police, the fire brigade.
Or other agencies
Where
there's an enactment
where there
which
is a precedence that is set. Because if there... No, we can't override the police. A police... In those situations, as we had mentioned earlier, that we would be establishing MOUs with some of these organizations that have that responsibility. But in terms of that investigative part where it is the police and the fire brigade, as we had set out right here, we are not in any way trying to...
So,
Yes,
Chair, what I
Sergeant,
was trying to
yes.
get an answer, this is not an issue now about police or fire brigade,
Yes,
for instance.
yes.
We're talking about competing regulators.
Yes, like the mining. Yes.
And the example given by Senator Brown was, say, in a bauxite area, there is an injury or death. Mining Act already has some powers. This act will have powers. I'm trying to find out from the ministry the policy intent, which act is to have precedence, because normally what we do is we have to indicate such. If we don't, we leave it to rules of statutory interpretation. And what can happen in a rule of statutory interpretation is, so you have different rules, competing rules. Later in time, usually can override. However, if there is a specific enactment dealing with the issue, even if you have a general enactment that is later in time, the specific will override. So in a bauxite situation, because it is specific to bauxite, the Mining Act could technically, under that rule of interpretation, override the OSH Act. So generally what you do is put in provision. So we've done it with PBMA, Public Bodies Management and Accountability Act. They will have rules generally guiding public sector bodies, but then you would have had public sector bodies who have been established under separate acts. What the PBMA says is if there is any inconsistency, the PBMA overrides. So this is why I'm just trying to find out the policy intent, whether they want OSH to override others or not.
And LRD was
Mrs.
just
Celia Brown, yes.
making the point. Look at the definition of branches of economic activity, paragraph C, on page 4, right? It includes, in accordance, it says these branches of economic activity includes, yes, in accordance with a MOU. Yeah, the definition. Remember, it was tagged on to right. It says in accordance with a MOU. No, we didn't delete it. We didn't know what it was, but we never deleted it. Right, it says between the director and the relevant entity under the act, with the approval of the minister, the economic activities.
where biological agents are.
Right. Remember
branches of the economy succumb to the margin.
Right, right. Remember, it was deleted because it was a separate definition.
No, but I don't have it as agreed by the committee. That part of the definition wasn't agreed.
Oh,
I don't have it as agreed.
but let us say, if we take it as it stands now, it is intended, the policy intent is to include these acts in the first schedule as being subjected to the Occupational Health and Safety Act. In the schedule it says it.
No, but it doesn't say that.
I know, I'm just saying, when you look at it, it says in the first schedule, it's just not properly drafted. It says the Occupational Safety and Health Act applies to economic activities under the following acts. And it lists these acts, the Mining Act.
Yes, but it doesn't mean that they are subject to this either. All it's saying is they are to have regard. So it is still
it needs
not
to be
clear.
clearer, but I'm saying, I
Oh.
think I'm agreeing with you, it needs to be clearer, but I'm saying that I think the intention, I don't know, I think that was the intention.
I'm sorry, but it's just that the intent is not clear. This does not say that, because an MOU can go either way. An MOU can basically give more rights to one entity than another. An MOU can also say that we are to work together. It does not indicate whether this is to override anything else. It just identifies all these other acts and says that all these other regulators for those acts there should be some understanding. But it cannot be a MOU arrangement. But that's the point.
Yeah. But then, Chair.
And that cannot be
Yes,
how
Mrs.
we do it in a
Silva,
law.
yes.
That's what I'm saying. So then, Chair, we need to then, when we get to the first schedule, we need to reconcile what that means, that the act applies to activities under these following acts. Because it is clear the OSH Act applies to economic activities under these acts, and it states the act. So if that is not what is intended or what is intended, it needs to be clearer.
Clearly stated. Okay.
One other thing, Chair,
Yes.
that it would say under the first schedule, this act overrides
Yes.
where applicable, but doesn't say so.
What I'm saying, it can't be said like this either. It must be a general provision up front in the bill. But it's just, I don't know.
You know, I agree, and that's, I think, what the Soldier is saying. We need to decide that and put it in the bill if we agree. If we don't agree...
And for you to decide that, you would have to bring the other persons here. There would have to be that type of discussion with the other regulators. It can't be just that you take this decision without their input. Because you see, are you saying you're going to override health when they have their very specific provisions in their Public Health Act, when there could be a potential overlap? You need to have those other persons come to indicate their views on something like that.
If we don't do that, this act won't apply to anybody, because look at the number of acts that are listed here. Pesticides Act, Public Health Act, Process, everything, Petroleum Act. So then what then is the purpose of the Occupational Health and Safety Act? If you're saying that it must be based on an MOU, yes. If that is really the policy intent, what is the purpose of this act? To whom will this act apply?
Very well. You have heard do you wish to say something, Mr. Simmons? Oh. Okay, very well. Ministry, you have heard the submissions. How do we proceed now?
Well, if you look back at the definition section, it wasn't the intent to be overriding. And if you look at the definition of branches of economic activity under C, although it was supposed to be revisited,
yes,
it was in accordance with the MOU.
What AGC is saying is that it has to be expressly stated.
And it was not our intent to expressly state that we would override, because these acts that were listed in the schedule, they have a safety and health component, and that is why we have to recognize this, and we would have to have these MOUs. That was the route that was being looked at, where there is that overlap, that those would be worked out. Member Brown was speaking about joint investigations. So that was that was the intent, and you have to recognize that the notice being issued is not automatic. It's not an automatic notice, the non-disturbance notice. It is so, and it is not required in all instances, because if you are part of a joint investigation, for example, if there is a death, the police will obviously be there as well. So being a part of that joint investigation, then the determinations would have between the agencies to say which is the best method, which is the best notice that needs to be issued if there are other notices, so that the multi-agency investigation can achieve its objectives.
Sure.
Yes.
If it's not an intention to be overriding, what's the fundamental difference with this proposed bill than the scope that currently exists in the Factories Bill Act? Because no, what I'm saying, no, so in other words, when I became a member of this committee and the initial conversations, that this was a revolutionary transformative bill, that everybody in the workplace, whether for profit or non-profit, so we all had the Ministry of Education came here and they thought that they were exempted, and when we had a discussion we realized that they are not. So all encompassing one big umbrella. Yes. After, no, ma'am, it's a day after coming here. So I'm hearing now, and an MOU can't be that binding. MOU is an understanding and agreement. Law is superior. So then again, so is this now a policy shift? We had that one major policy shift to the authority. But I hear it's not intended to be binding or overriding. Then how are you going to enforce this then? So you go to an institution, many agencies have provisions in their legislation that guides them to deal with safety and health. But if this isn't, I thought this would be the supreme law for all workplace in the society. And then others will have to make the adjustments over time, if not in law, but in practice. But if we are hearing that's not the intention, we could be here deliberating an act to become law that basically is of no fundamental use or no difference. And I don't want that, because I was excited coming to the committee and deliberating, but it can't be just to pass these laws and then it only applicable to what currently exists under the Factories Act. More and more, and even what I've said that many times, more and more as I go through the provisions, I get the feeling we are only making amendments, if not directly, but just by practice to what currently exists. And I thought that this was far more revolutionary. And it is. But if it can't encompass all, then it really makes little no sense.
Very well, Member Skeffrey. Member Longmore, you...
I'm still processing. I'll chime in later.
Very well. Well, in terms of the...
Leave the people and let them talk.
Yes.
But what is clear, Chair?
Yes.
We now need to probably say under the first schedule, it's now 27 Act, including the Defense Act and the Constabulary Force Act. We have to create a 28 Occupational Safety and Health Act, because that seems to be the order of precedence that will weigh down the bottom. Because with all of this, something at the airport, it says, unless we have an MOU before, we're going to have to create it after, so we can't go to the airport to deal with that. This needs to be clarified. What does the first schedule mean?
Yes.
What is intended? I think that's the position of the AG.
By virtue of the concerns highlighted by both CPC and the AGC, the ministry definitely has to come back to this committee in that regard. So we will get the necessary clarity, have the discussions, and be clear on the policy that will guide us going forward. So in respect of this particular point, the ministry will come back to the committee at a later date. Yes. Yes, it is 8 minutes past 1. I'm told that the lunch is ready. Members, I don't know if this is a convenient time.
To lunch, Chair, we need to come back and have a discussion about this, because I was having a totally different concept of how it would work. But I'm taking Mrs. Aldred's point, and now that I've looked at the CARICOM draft and see how they have done it.
Do we close off on this point?
No, let's have lunch first and then come back.
Member Cuthbert, you wish to say something? Yes.
I think, as you just mentioned, the CARICOM, I wanted to find out, there are other countries in this section of the world that has this. How did they draft it? By looking at the other acts as we have here, for it to be consistent with whatever it is that we want. I was also of the belief that the reason why we had a joint select and had all the different entities, companies coming here, was to really look at what is in this and to make the necessary adjustments to make it what it should be. That where everybody would, once we have a proper bill, then it would actually fit in with whatever is the standard in their company at this time. And so, while we're possibly a little bit ruffled right now, I think it, once we look at other jurisdiction and see how it is, because it must be a policy directive, and that should override pretty much everything that there is in whichever company. I'm thinking. So I think what we need to do is still, go to lunch, come back, and I'm sure I would love to hear what the Solicitor General has to say, what you guys have to say about how we proceed and move forward.
Chairman,
yes,
if I may, and I'm trying to orchestrate and wrap my mind around.
Yes.
I approached it, and my challenge is this, that my natural inclination to approach the situation is different than what is drafted. Because I see it as primarily the health and safety of the worker, which for me falls clearly, to me, between labor and health. Now, in terms of, and I'm just breaking it down simply for what we are hoping to accomplish, in terms of the recognition of a risk to a worker, which is a health risk, it is either mild, moderate, or severe. Our interventions that the OSH officer would see to would be based upon those assessments of mild, moderate, severe, which you now have kind of categorized as serious illness. But in the medical world, we see it as those three breakdowns, however we want to equate it. Now, you also have severity based on not just if it's one worker versus 200 workers, based on the number of persons exposed and also the severity of the individual exposure. Therein lies where other legislations may also be applied and the extent to whether or not criminal activity is engaged. So the Factories Act, the Fire Brigade, all of those other acts are supposed to be in line with an overarching Health and Safety Act that is enacted enacted by the relevant, in my mind, two ministries, which are health and worker, labor and health. And I go back to my utterance of the lack of the inclusion of health in the drafting. In the drafting.
Yes. All right. I've heard the comments, members.
Just
yes?
to leave everybody with a little thought before we go our separate ways for lunch. The problem we have in Jamaica. So there is something in the CARICOM model bill, but you see, you can't always take something and think that just because it applied, you have it in a model bill. Things that you have done, say, in St. Lucia may not always apply here. What some industries would have done is gone ahead and provide some very specific provisions because we didn't have an OSH, right? And so what I am struggling with is, under Public Health Act, you have all these various regulations that deal with very specific things. I think they're trying to come with things for funeral homes. Are you saying that OSH is going to now override those recent new regulations they're doing under that? My issue is, where we have a gap, there's no problem, OSH should apply. Where you have an inconsistency, what happens then? Because I don't know if we have really thought it through.
OSH is to see to the compliance of those other regulations. So like you're saying about parlors, funeral homes, etc., etc., OSH should see to the regulation of that, to ensure that that is through the ministry, so that is complied to. So this is an overarching act, and the primary purpose of it is to ensure the compliance to those, whatever industry it is, that those are adhered to.
So because we have not approached it in that way and we're now coming and playing catch up, the issue again is, where we have these little inconsistencies, what will happen?
before we go to lunch.
Yes.
Now, Mrs. Aldred is quite right. And what I think happened is that we picked a precedent and then we pulled things from the CARICOM draft without more. When I'm looking at the way the precedent dealt with it now, they obviously had rather than a Public Health Act, they had a Health and Safety in Employment Act. And under that act, you had a whole heap of regulations like what we have under the Public Health Act. So what they did, they incorporated their public, see that is why you hear Senator Longmore keeps on saying there's an overlap between the public health functions and the others. So they incorporated those provisions in this act, and all of the regulations under those acts, they deemed them to be regulations made under the Occupational Health and Safety Act. So that's how it was dealt with there. But we pulled it without examining, and then we tried to do this makeshift thing where we have this MOU and state that these acts would apply, and I think that is where the issue is. So that needs to be seriously addressed, Chair.
Mr. Chair, just one quick request when we return from lunch. This draft bill naturally was done within a context of a policy. So I hear that's not the intent for it to be override, but I would love you in your capacity as a chair / ministers here, just to summarize what was the policy that guided us. Because what I'm saying, no, but it's clear, we are here examining a bill that is drafted with a policy, and I had a clear understanding as to what it was intended to do, intention, and I'm sure my colleagues here too. But as we proceed now, I am seeing a shift. So I just want to be clear that was it a misinterpretation on my part as to the direction, or is it a shift? Because remember, just similar to the whole notion that we got a shift in terms of the authority. So I just want to be clear, because we can only discuss the bill and the various provisions in the context of the intent. So, and only you as the minister can remind us, along with the technical team, of course, as to the context in which we are discussing the bill, because that's what is important. So if it is not the intention to be broad-based, as I had thought, then clear, and is that the way we want to go? If that's a policy, we have no choice. But I would be disappointed in the context, because that was my understanding for the period I've sat on this committee.
Yes. So certainly, Members Kefri, in specific reply to your question, in terms of how we proceed as a... No, well, I know it's lunchtime. Yes. So definitely we will resume this conversation post-lunch immediately, and we will shed some clarity on the policy of the ministry at that time. So we will now recess for lunch, and we resume 2 p.m. So we now break for lunch. We resume at 2. Yes, good.